Well, good morning, Council. This is our first case on the February docket. I'm pleased today to be sitting with Judge Tom Malone, who formerly was a Sedgwick County District Court judge and joined our court in 2003, and Senior Judge Richard Walker, who was a district court judge for 18 years before he retired in the 9th Judicial District and has been sitting with our court since 2015. And I'm David Bruns. I've been sitting with the Court of Appeals since 2011, and before that I was a judge on the Shawnee County District Court. This morning, our first case is a workers' compensation case, Kendall Turner versus Pleasant Acres LLC and the Kansas Workers' Compensation Fund. Would you please state your appearances?
Andy Stolick on behalf of claimant.
Your Honor, Tim Emerson on behalf of the Kansas Workers' Compensation Fund and the appellant.
And Mr. Emerson, representing the appellant, would you like to reserve any of your 15 minutes for rebuttal?
Yes, Your Honor, 5 minutes, please.
5 minutes, so 10 and 5. With that, Mr. Emerson, you may proceed.
Thank you, Your Honor. The crux of this appeal actually appears as the last argument in the appellant's brief. So with the court's permission, I'd kind of like to go backwards today. I'd like to talk about the crux of the appeal, which is the statute KSA 44-504, and then work backwards to incorporate the other issues for appeal today.
That's fine.
One of the things that I learned early on, in fact, in law school from Dean Concannon, was to not think great thoughts, to read the statute. And I think that's an appropriate place to begin with this argument today, in that the Kansas Workers' Compensation Statute has a provision, specifically 44-504, which is referenced on page 14 of the appellant's brief. Essentially, what the statute indicates is that the claimant has a right to workers' compensation benefits. The claimant has a right to pursue a third party when appropriate. And one of the reasons for this statute is that when there is a third party claim available to a particular claimant, as there was in this case, there's no need for two insurance carriers, or in this case, the Kansas Workers' Compensation Fund, to be pointing at each other as to who should provide benefits to the claimant while the claimant sits in limbo. The purpose of the statute is to make sure that the medical benefits that are pretty urgent and immediate are provided to the claimant, and also to prevent the claimant from engaging in double recovery. And I'll get to that in just a moment. But what we don't want is a claimant waiting for someone to step up, or an entity to step up and indicate that, we will pay those benefits. So typically, it's the workers' compensation carrier that handles the lost wages or the temporary total disability benefits, which the claimant did receive in this case, and also the medical benefits in the form of medical treatment, which the claimant did receive in this case. As is stated in our brief, kind of the procedural history of this is that the claimant, while at the same time receiving workers' compensation benefits, hired counsel in Wichita, Brad Pistotnik, to pursue or assist him with a civil action against the estate of the deceased driver. This was a situation where the claimant was working for the respondent, Pleasant Acres LLC, and was driving a truck when another driver crossed the center line and they had a collision. At the time of the collision, the claimant did not believe he had been injured, but subsequently sought some treatment and received that treatment. So he hires counsel to assist him with a civil action against the estate of the deceased. What ends up happening is we find out that the driver, the decedent driver, was uninsured. So that ended up being an uninsured motorist action directly against Continental Western Insurance Company. Now, the two parts of the statute that my appeal, or the fund's appeal, has focused on is the fact that the approach is two-pronged when looking at KSA 44504, and that is to preserve the injured worker's claims against third parties, which was done in this case. He indeed pursued a claim against a third party, albeit through an uninsured motorist action, and to prevent double recoveries by workers.
Counsel, before we get there, did you receive notice of this underlying tort action?
I did not. Actually, this was not something that was discovered until after the regular hearing was held in this case. And
well, I noticed the statute provides the employer shall receive notice of the action, have a right to intervene, and may participate in the action. I know this is a little unusual because you're standing in the shoes for the employer as the fund. Do we know if the employer was given notice of the action?
I don't have a way of knowing that, Your Honor. This was a situation where Pleasant Acres, as I understand it, initially did not have much of any communication on the case. This is also a case that I inherited after another attorney had already been representing the fund, and then it was passed over to me. I will note, Your Honor, that there was an attorney who represented the respondent early on in the case. And then I think Mr. Stalkup would disagree with me, or would agree with me, sort of disappeared as the case proceeded. So in turn, the respondent disappeared from participating in the action as well.
Okay.
So the regular hearing was when it was discovered by the fund that there was a third party action. And in fact, there were specific questions asked of the claimant on the stand as to whether he had been pursuing this third party action. His answers indicated that he had not. And it was only discovered later through medical records reviews that he had actually said something to one of the providers that, hey, one of my cases has settled, and hopefully the next case will settle in September. His reference to September was a reference to the running of the terminal date in the workers' compensation case. What I did at that time as counsel for the fund was ask the judge at the time, Pamela Fuller, to suspend terminal dates so that we could take additional evidence, because with this epiphany that there had been a civil case out there that may have been collected upon, I needed to take his deposition again. We did that. We took his deposition. We discovered that he had already received $230,000 directly from Continental Western Insurance through a uninsured motorist action. The argument that the fund has been making in this case in our briefs and at the board level and at the administrative level, I will note Judge Fuller ultimately recused herself from the case, and it was assigned to a different administrative law judge who about 4.5 months later issued a decision on the case. The focus of the decision that the judge handed down and that the board affirmed was heavily reliant on the Knight case, which is cited in our brief.
Well, help us understand. Knight was a 1981 case, 10th Circuit, arising out of Kansas, where Judge Earl O'Connor ruled one way, and then the 10th Circuit ruled another way. And it looks like everybody's pretty much been following Knight since that time. Is this the first time that this issue's been presented to the appellate courts in Kansas?
As best I can tell, when shepherdizing the case, actually 4 cases come up. 3 of them aren't even Kansas cases. What I will note is in the Knight case, that was the federal court, as you know, asserting that they believed that the Supreme Court of Kansas would accept the plaintiff's interpretation of the issue. As best I can tell, it has not been presented in this form to an appellate court. Has the Workers' Compensation Board been applying Knight ever since 1981? Have practitioners been following Knight? What's been the status? 1981, April of 1981, I think it was. I was just being admitted into law school that year, so that's been a long time ago. So, what's been the status of Knight throughout these last 30-some years? And Your Honor, what I've found is I found the Lux case which references Knight. That's cited in our brief, 272 Kansas 710. That was at the Supreme Court, and that actually distinguished Knight on the issue of underinsured motorist benefits. I don't have any research to indicate how often the issue has come before the board.
Do you know if it has?
Oh, well, I know it certainly has in this case. And I know that.
No, I mean, in prior cases in this intervening time.
I don't know what the treatment of that has been, but in looking in the appellate realm, I found very little. And in fact, I only found the Lux case, which was actually at the Kansas Supreme Court back in 2001. To get to the ultimate point of the reason why the fund has appealed this particular part of the board decision is that the court has treated benefits that are received or recovered in contract, i.e. the uninsured motorist benefits, differently than tort benefits. The fund's argument, and it's pretty well outlined in the brief, is that in order for Mr. Turner in this case to have collected benefits through the uninsured motorist benefits of his employer's automobile policy, those same damages had to have been measured in tort in order to ever reach any kind of contractual obligation for the uninsured motorist benefits to be paid. In other words, we're splitting hairs when we indicate that these are contractual benefits and not tort.
Well, they're hybrid, aren't they? Hybrid benefits. The contractual obligation is only triggered if you can prove negligence, causation, and damages, just like you would in any other tort case.
And I agree, but in Kansas workers' compensation cases, we have a specific statute that tries to prevent from duplicate recovery. And in fact, as the statute was being interpreted early on, and there were cases where people were asserting damages in their third-party action of loss of consortium or loss of services of a spouse, what the legislature did was the legislature actually incorporated that statutorily and said, we're going to make this change because there is no loss of consortium in workers' compensation. There is no loss of services of a spouse in workers' compensation. So we're going to incorporate that into KSA 44-504. And they've done so. They have not similarly done so with respect to contractual damages. It's the fund.
So if we were to accept your argument, I take it the remedy then would be to send it back to the Workers' Compensation Board to determine what is and is not duplicative?
That would be the fund's approach to it. I would agree with that approach.
Okay, so you're a little over even 10 minutes. Do you want to go ahead and hit on your other issues real quickly, and then so you'll still have some time for rebuttal?
Essentially, and again, it's outlined in the brief, the subsequent history of after learning about this recovery that the claimant had made, we went on to take additional depositions. And in fact, we took the deposition again of the claimant, learned about the recovery of the third-party action. We also took the deposition of Dr. David Hufford, who had previously treated the claimant and given an opinion on impairment. We did not retake the depositions of anyone else, the vocation experts or the claimant's chosen medical expert in the case. Those depositions were not retaken. So those depositions, Dr. Hufford changed his opinion on impairment after learning that there were certain elements of claimant's case that we did not know until we had to do some further investigation, despite our questions of the claimant under oath. Dr. Hufford used that information to add some discretion to what his prior impairment rating was, and he determined that, this is speculation, but he did lower his impairment rating, and I think that it had something to do with the believability of what claimant had told him during the oral history that had been given to him during his treatment. Those things were pointed out to that one witness, not to any additional witnesses, so it's the fund's position that Dr. David Hufford's opinion should be given deference. Dr. David Hufford determined in his opinion that claimant could indeed work and was not permanently and totally disabled. That is the crux of the other arguments that we've had in this case. Similarly, he indicated that there was no future medical treatment indicated, whereas Dr. Zimmerman had determined that there might be the need for some additional future medical treatment. It's the fund's position that that does not rise to the level of the requirement to prove that future medical is indeed needed, might benefit from medication, et cetera. So those are the additional arguments on appeal. But again, the crux of it is the application of Knight to 44-504.
Okay, thank you, counsel. You'll have a couple minutes left over for rebuttal. Mr. Stalkup.
Yes, thank you, Your Honor. The position of claimant in this matter is that Knight versus INA is controlling. Mr. Emerson is correct in that, or at least I agree with him. The only other mention by the Kansas appellate court system since Knight is the Lux, if I'm pronouncing that correctly. In that particular case, dealt with UIM, underinsured motorist provisions and benefits. And in that case, the court held the substitute payment qualified as a liability payment, and therefore granted the lien of the or subrogation interest. I apologize.
Mr. Stalkup,
Yes.
before you go on, I know you've practiced a lot of work comp law over the years.
Yes.
Knight was a 1981 case. I think we all agree there's not much out there appellate wise, at least in Kansas, interpreting Knight. Has Knight been applied by the Workers' Compensation Board since 1981? Have practitioners relied upon it? What's kind of been the status, or has it just kind of been forgotten until now?
I don't know what the status is. I wish I could, and you're right, I've practiced a lot of workers' compensation. I have never come across this particular issue in my practice in front of the board, and I don't even recall a case in front of any of the ALJs. I only infer from that, if it has cropped up, it has been very rare. I am unaware of any other case that specifically addresses this by the board.
Okay, thank you.
You bet. And but my point is, this is a claim. It is an uninsured claim, and Knight is controlling on that. I think that's apparent from the fact that it's never been reversed. It's mentioned a few times in other cases, but the only other time I could find it was in the Locks case. And there may have been another, there was a case I think came out of Colorado in which, and that was a federal decision or a United States District Court decision, I believe, and they did not attempt to change it. They supported it. I guess we could argue about whether or not they'd be allowed to do that and not the appellate level, but nonetheless, agreed with provisions. It is simply a straightforward contract action. The predicate is proof of, in order to recover on that contract of uninsured benefits, one must prove that there was a tort, that indeed there were damages, and that there was negligence on the behalf of the tortfeasor. This particular tortfeasor, as the court is probably aware, was pronounced dead at the scene and did not have any insurance at all. There was no insurance coverage, so Mr. Pistani pursued a claim for the uninsured benefits against Continental Western, which was the company that provided the vehicular policy for that particular 18-wheel unit that was being driven by the claimant. So we believe that's still good law, that there's no reason to change it. I don't know that Mr. Emerson has cited any case or statute that would merit reversal of that decision. So I would urge the court to continue with that decision as set forth in that case. In regard to the medical experts' opinions, Dr. Hufford was the neutral physician. He initially opined 8%. He later changed that opinion to 7%. Mr. Emerson asked several questions of Dr. Hufford on his second deposition about previous settlements. The record will show that I objected to those questions and the introduction of exhibits 3 and 4, which were the settlement documents for the 1995 and 1997 work comp cases, as not being allowed. MESA, I believe, controls that. Those documents were excluded by the ALJ in this case, as well as by the board. I further object on the basis that hypothetical questions involving those documents should also be disregarded. So in my opinion, Dr. Hufford's impairment rating opinion of 8% should stand. If the court is dissuaded and believes the 7% is more appropriate, there is no statute or case law that says the neutral position's impairment rating opinion should be followed exclusively to any other opinion expressed by any other doctor. And obviously, if you take the 7 plus the 9, you come up with, I think, 16, which divided by 2, if it's averaged, then equals 8%. That's pivotal because the threshold medical impairment rating for work disability award is an amount in excess of 7.5%. So I believe the court and the board reached the appropriate decision. I would have perhaps taken a different route as expressed in my cross appeal, but would ask this court to uphold the decision of permanent total disability. And in that regard, even Dr. Hufford testified that he would not pass the claimant on a DOT, Department of Transportation exam, and he has accomplished that as part of his practice. Mr. Emerson did object to that, but I did ask that, and that was Dr. Hufford's opinion. Both doctors expressed loss of task being, as 57% by Dr. Hufford, and I think it was 71% by Dr. Zimmerman, but they both concluded that he is permanently and totally disabled. Proviso being with Dr. Hufford that if he could not drive a truck, he would not pass him. He considered him to be permanently and totally disabled, which even Mr. Benjamin, the work comp funds retained vocational expert, agreed, trusting that the claimant in that situation was not able to operate a vehicle. So that completes my presentation. Happy to answer any questions.
Do any of my colleagues have any questions for Mr. Stalka? Thank you. Mr. Emerson, I'll give you a couple minutes for rebuttal.
Yes, Your Honor. And I'm just going to focus on Knight. Knight was, as you all have mentioned, it was decided when I was 11 years old. It was an action that was directed against the insurance carrier. It should be noted in that case that the employer did not contest the right of the employee to recover on what was considered a contract claim. The 4 cases that I found in trying to determine whether Knight had been consistently followed, as has been mentioned and as was cited in our brief, the Lux case deals with underinsured motorist benefits. And it seems that the justification there for the decision to allow subrogation in that instance was that there was a substitution. Therefore, it was determined to be a recovery in tort because of that substitution. I think the fund's position is that we have a problem with splitting hairs between contract and tort. And we've talked a little bit about the hybrid approach as well. But in this particular situation, the cases that I found, and I'll just state those very quickly, a Delaware case, Harris versus Newcastle County, 513A, 2nd, 1307. There they disagreed with Knight, and they found that to adopt a construction of the statute that would determine subrogation rights on the basis of the nature of the cause of action would elevate form over substance. And I think that that's important here as well, because even though generally speaking, Kansas courts will look at underinsured motorist benefits, other than in the Lux case, and uninsured motorist benefits as being contractual in nature, they are nevertheless measured by tort damages. And that goes back to the intent of the statute, The statute itself is there to prevent a double recovery, which is exactly what occurred here. If the difference was that the decedent had been insured, the outcome would be completely different. And when we split hairs like that, I believe that we dilute the intention of the statute. And here, this gentleman was able to get a recovery through the third party action, and also able to get a recovery through the workers' compensation process. And just to end our arguments, there were a couple of other cases that declined to follow Knight, and that was Travelers versus Liberty Mutual, 164 Vermont 368, and also National Farmers Union. This is the Colorado case that Mr. Stalkup may have been referring to, versus Bang, and that was 516 Northwest 2nd 313, declining to follow Knight. The fund's position is that it is more consistent for the statute, to the second portion of the statute, to be followed in a case like this to prevent such double recovery, and to find otherwise would be not in line with the statute and also inconsistent. And finally, just pointing out that as the cases evolved over time in interpreting this statute, when there were things that should be excluded, like loss of consortium and loss of services to a spouse, those were incorporated directly into the current iteration of the statute. No such thing exists for the argument that contractual benefits should not be subrogable. So that is the fund's position. And if there are questions, I'm happy to answer.
I've got
Judge Walker.
a comment and then a question. My comment is my experience is the chief function of the courts on many days is to split hairs. And because that involves interpretation, which a lot of times is sometimes a little better than a coin flip at the Super Bowl. But my question is, isn't the real answer here a legislative fix? I mean, Knight's been in existence for 40 years, and the defense bar is very active in before the legislature in the workers' comp area. If this was such a problem, why hasn't the legislature been asked to fix it?
I mentioned that there is not a similar provision in there for loss of consortium and the loss of services to a spouse, where the legislature has gone in and excluded contractual benefits. That doesn't exist in there. So the argument is that it's fair game. The general law in the state of Kansas is that those are contractual benefits, but there is no preclusion of that in the statute. And one would think that if that was to be precluded, it would actually be in the statute. And I agree with Mr. Stalkup. In looking at Knight and the application of Knight by the state appellate courts in Kansas, we find one case, and what they did was distinguish Knight. There aren't cases where the appellate courts have happily and aggressively said Knight is good law and we intend to follow that. The one time that it has come up, at least that opposing counsel and I have found, is the Lux case where it was distinguished.
All right. Thank you. You've answered my question.
Thank you.
Any other questions from the panel? If not, thank you, counsel. Good arguments, unique case. We will do our best to get an opinion out to you soon. And in the meantime, we'll take this case under advisement. Thank you all.
Thanks very much.